Hey everyone, welcome to another video. So in this video, we'll try and understand a very crucial Supreme Court judgment which came on 4th of December 2025, which settled a lot of disputes surrounding the term residential dwelling. Now, under GST, as far as rental or lease services are concerned, if there's a landlord providing rental services to a tenant wherein the rental accommodation for residential use is being provided to the tenant, then there'll be no GST coming into the picture. It'll be totally exempt if this particular accommodation is used purely for residential purposes. So if the tenant is using the accommodation provided by the landlord for residential dwelling for 100% pure residence, then on this particular transaction, there'll be no GST. GST is exempt. The landlord or the tenant will not have to pay GST. Even if the tenant has got a GST registration, because the ultimate purpose is for residential dwelling or for long-term residential accommodation, there'll be no GST here. It will be completely exempt. But if it's a commercial purpose or if it's a residential purpose, but a commercial tenant is being occupying the particular accommodation, GST will apply. But for this particular discussion, for this particular purpose, if the house or accommodation is used purely for residential purposes, there will be no GST, it will be exempt. Now, what happened in this particular case that was dealt by the Supreme Court and for which a judgment came out was basically that on one side you have a landlord and the landlord provided a accommodation that was meant for residence to a party called D12 Spaces on lease, of course, on rent. So rental services were provided to the tenant, and tenant here is D12 Spaces, a private limited company. And what D12 Spaces did is they further subleased the accommodation to students and working professionals so they can come occupy the accommodation, stay for a long period of time. So in this case, the ultimate tenant was, of course, the students, professionals, but the landlord had provided rental services D12, and this accommodation is used for residential purposes by the students or professionals given by D12 Spaces. Now the question here was whether GST is payable either by the landlord if the landlord has a GST registration, or by D12 Spaces where D12 Spaces had to pay GST on reverse charge basis, being a company. Now the GST department said that because D12 Spaces itself is not occupying this particular accommodation for residential purposes, the ultimate owner or the ultimate user of this particular rental service is the students, the professionals. It is not being used for residential dwelling by the tenant, the first tenant, and therefore GST will be applicable. So this was a situation, and the term residential dwelling was being disputed, for which a judgment was sought by the higher court. So what the GST department said is that, one, the term residential dwelling is basically not defined in the GST law, but it means residential accommodation for the long term. And it said that in this particular case, the first tenant being D12 Spaces, did not use the rental accommodation by itself, and because the tenant should use by self to call it a residential dwelling, otherwise GST will be applicable. In other words, the GST department said that because the accommodation provided by the landlord was not used by D12 Spaces itself for residential dwelling or accommodation, but was used by the students or the working professionals, in this particular case, it does not tantamount to residential dwelling, and therefore GST will be liable to be paid by the landlord or on RCM basis by D12. Against this, D12 filed an appeal to the High Court against the department's order, and the High Court brought out a judgment which said that the ultimate use should be considered and not the user. So what the High Court said is that it doesn't matter who the ultimate user it is whether it is D12 Spaces or students or professionals. The ultimate use is what it matters, whether it is for a commercial purpose or for a long-term residential purpose, residential accommodation purpose. And because this is for a long-term residential accommodation purpose, it satisfies the criteria of residential dwelling, and GST will be exempt in this particular case, because High Court looked at the ultimate purpose or use and not the ultimate user. And again, against the High Court's order, the department filed an appeal to Supreme Court, and a judgment was sought from this particular apex court. And what the Supreme Court said is that, one, it sided by the High Court's judgment, which said that the activity should be exempted or considered and not the person. It is irrelevant as to which person had used the accommodation for residential purposes. The ultimate purpose or the activity or the use was residential dwelling or residential purpose, and therefore GST will be exempted. Look at the activity and not the person. Number one. Number two, don't make a narrow interpretation or a literal interpretation of the word must use for residential purpose. Only the use matters and not the ultimate user. So don't do a lateral or a literal or a narrow interpretation. Number two. Number three, if you do such kind of an interpretation, then it will ultimately defeat the legislative intent brought out by the government of providing GST exemption. Because if you charge GST on detailed spaces, they'll ultimately charge it to the final students or the working professionals, for which the fee of staying would be quite high. So if you interpret it very narrowly, then in a narrow manner, then definitely it will defeat the legislative intent of this particular GST exemption clause. So what the High Court finally said is that it upheld the Supreme Court upheld the High Court decision and said that activity should be considered and not the person. To satisfy the criteria of residential dwelling, you have to look at the ultimate use and not the ultimate person or the user who uses the accommodation for a residential purpose. Of course, there should be three conditions. One, rental services should be provided, accommodation should be of residential nature, and it should be used for residential dwelling. There is no condition that the user must be the tenant itself. The user can be a third party also, because in this case it was subleased to students or working professionals. So this judgment goes in favor of a lot of private hostels wherein a company takes accommodation on lease from the first owner and then subleases it to a school or a private institution wherein hostelites coming, students coming, working professionals coming, and they pay fees for staying in for a long term, for a long term residential purpose. Well, I hope I was able to make things clear through this particular video. If you like the video, you could show support to us by hitting the like button. If you want more videos like these on regular basis through way of notifications, you could also think of hitting on the subscribe button. Till then, I'll see you guys in the next video. Take care and thank you.